that. Hi, good evening, everyone.
Good evening.
Evening.
Welcome, welcome. Looking forward to this one tonight. Thank you so much, Ayo, for hosting.
That's fine. Just let me know whenever you're ready for me to start, and I will show my equally tired face. And I've removed my wig, so it's a scarf tonight, guys.
Yeah, you come home, unwind, relax. You're among friends. Who's on the phone? I can't see a name on there. Who's there? Hello. Oh, who came in? Who's on iPhone?
All right. I wonder who that is.
I know, we've said hello and let you in, but we're not sure who we are. Hello.
It's Maggie. Sorry, I'll correct myself.
Maggie, is that you?
Oh, hey, Maggie.
Yes,
Yay! Wow, wow. It's
let me
good to have you
rename
here.
it. Let me rename my thing so you can see me.
Yes, let us know you're here.
That's it. Beautiful. There I am.
Fantastic. Welcome,
There I
Maggie.
am.
It's brilliant to have you here. I know you've been so busy and had your ups and downs like me, but I'm so glad
It's
you're
crazy. It's crazy. It's crazy.
here.
I'm so glad. I'm blessed to be here.
Yes.
My first day off.
Oh, wow.
Yeah. My first Thursday off in a very long time.
Oh, well, I'm glad you come to spend it with us.
Yes.
You're in good company.
Okay, Ayash, you want to kickstart now?
Yes, I can.
You don't look
also
bad.
just want to also I do want to apologize in case you hear screaming downstairs. My husband is trying to contend with two kids.
Yeah.
One who's refusing to eat and the other who's refusing to be by herself. So
real stuff. Yeah.
So if I click present, and let me see if I share my screen and
Brilliant.
see that?
Yes.
Okay. So I've got notes in front of me and I've got this here. So if I look that way, I'm just looking at the PowerPoint presentation.
Okay.
So, okay, good evening, everyone. And welcome to the Contracts for Coaches. I know last time, I think it's actually the last session I did was also on contracts, I believe. But I think we were talking about the types of contracts you need in businesses, the contracts every entrepreneur should know. So this one is specific for ADC, seeing as you are an association of Black coaches or coaches. So we're going to talk about contracts for coaches. At the beginning, we will touch slightly on some of the elements from the last session, just to kind of reiterate the importance of a contract and why you do need it. So, like I always do, quick disclaimer: this is just for informational purposes only. If you need legal advice, please seek a legal advisor. So I'm going to skip the about me. It's not my first time here. I don't think it's the first time everyone has seen my face. But if you do want to know more, just visit at Lead Collective 1 on Instagram, or send me an email, or ask Shireen and Mary, and they can put you in contact with me. So just to reiterate what I said last time, handshake deals are dead. If you are a business owner of any kind, of any form, do not do a handshake deal with anyone. Conducting a business without a signed agreement has resulted in so many businesses losing out on money, on ownership of intellectual property, entering into bad business deals. So in order for you to protect your business, stop shaking hands. Everything needs to be in writing. So what is a contract? A contract is a legally binding promise by one person to fulfill an obligation to another person in return for consideration, which in most times is money or a service. So one of the things is it has to be a clear offer, there has to be a clear acceptance, there needs to be an intention to create a legal relationship. So by signing, when you look at the bottom of contracts, by signing it, that creates the intention of a legal relationship. And then there has to be consideration. So giving up something for something else. mainly money in exchange for goods or services. These are the four things, the four elements that make a contract legally binding. So moving on to the key one for today, which I would move on if I can. Oh, I don't seem to be able to. Okay. How to create a coaching contract. So why do you need a coaching contract, first of all? First things first is to build trust. Your legal agreements will make clients trust you more, and that way they can also improve your coaching services. Secondly, if you're able to, how do I put it? Okay, so if you already have a couple of coaching clients, you know that different things can happen, i.e., a client doesn't appreciate you, so they ghost you for no apparent reason, and then they can, they blame you for not getting their results, or, a client keeps rescheduling with just like a few hours or few minutes notice. People who send refund requests long after your refund, period has expired. These situations can be rare for people, but it still happens. Therefore, you need a contract to protect yourself. It also allows you to set boundaries. So a one-to-one coaching contract is the first agreement or legal document you need to have in place as a coach. That's what I always tell people. If you're serious about your business, you should be legally protected from the very beginning. It helps you save time, energy, a lot of stress. You save your edges and your hair too. When you have clear boundaries in your business. Establishing a coaching agreement helps you to set the terms for your coaching. So it helps you say, I like to say, it helps you say, this is how I conduct my coaching calls. This is how I conduct my sessions. This is how I respond to messages. And this is how much you can get out of me, or this is what you can get out of me. It sets all these things out. An agreement also makes it clear what your coaching program is all about. It protects you and it protects your client. It shows your client what they can and cannot do with your content and with the program. So it can protect your income. Like I said here, outlines both of your responsibilities. It sets payment terms and also sets the terms, like I said before, of your coaching call or the coaching program, and so much more. Like there are so many things a contract can do for you in your coaching business. Please do let me know if I'm going too fast. So I like to use an example of one of the reasons why this is so important, why you need one, and it's for refunds and chargebacks. So refunds, if you're delivering what you promise, a contract helps you to feel assured that you are protected legally from wrongful refund requests. So you've done your part, you have fulfilled your obligation. So if a client was to come to you and say, oh, I need a refund because I didn't get the results I wanted, you can pull out the contract and say, well, I said I was going to do A, B, and C. You had a responsibility to do A, B, and C. I did my part. Clearly, you probably didn't do your part, hence why you didn't get the results you wanted. So it helps you against things like that. It can help you against chargebacks, that you can show your contract to a credit card company that you've met your terms and you've honored your part of the agreement, but the client isn't honoring their part of the agreement. So for any coach that takes credit card payments, for example, you know how easy it is for someone to go back to their bank and say, this is fraudulent or this is that, and the bank would stop the payment or they do all that process. So that can help you, in that situation as well. And a client who has read and agreed to your terms is therefore then responsible for acting in accordance with those terms. So they don't really have much legroom to stand on. It's not your fault if they take your contract and don't read it. Just for you as a coach is to make sure you have those things in place. I'm going to take out my earrings. I think they keep hitting the mic. So there's no moment. All right, sorry about that. So like I said, your client would have or should have read their contract. So you've effectively, you've done your part. So be rest assured once you have one. So what are some of the common misconceptions about coaching contracts? The first one, that the content that you and your client own. There's a misconception as to what you own and what they own. So your contract will probably state something like, you own your content and your client owns the content that they share with you during the coaching program, but there's always an exception to the rule. Your contract might mention that if a client shares a testimonial, let's say, for example, in a Facebook page, or via an email, you can use it without having to ask. I always say with things like that, make it clear. Testimonials are very, very important to a coaching to a coaching business. So make it clear how you want, who owns what. So for example, if they posted it publicly on your Facebook page, it's public now. You can always add that into your contract. That those kind of testimonials you can take and you can share. If it's something that they've said to you privately, you might need to put a caveat in there saying you can use it provided you've asked them for permission. So things like they could get very tricky. Another thing is about non-defamation clauses. So most coaching contracts have a non-defamation clause that states that a client can't post false information about the coach. Now, this doesn't mean, however, that the client can't post an honest bad review. Nobody wants that. So it's not all the time if they say something negative that it's defamatory to you, because it could be factual to them and to their experience. So instead, however, a defamation is a false statement that discredits your reputation. So you've got to be able to differentiate between whether or not their statement is just a review of their experience and the experience they had with you, or if it's attacking you and defamatory to you. So for example, I like examples just so I can make it clear to you. If a client badmouths a coach because they don't feel like paying, or the coach holds them to the contract they've signed, that would likely be defamation. A review, on the other hand, is a review of the coaching services and their results. Number 3 is responsibility for other clients. So for example, let's say you were running a group coaching program, so you weren't doing one-on-one sessions, or you had a course, for example, where your students and your clients interact on, let's say, a private Facebook group, because that's what most people do. The question is always, are you responsible for how your clients behave in that group? So one of the possible scenarios is that on a public forum like that, everybody is sharing ideas, right? So a possible scenario is that one student might steal another idea or content from another student, from another client. So most coaching contracts will say that a coach can't be responsible for this. And I think it's very smart for you to say that you cannot be responsible. You can't be held liable if somebody else steals somebody else's idea, but you do have a way of dealing with that conflict if that were to arise. So the truth of the matter is, if you have a public forum like that, your job as a coach is to just monitor the situations. So you really need to have that in your contract as well. You're not necessarily responsible for everybody else that's in that group. All you can do is manage the situations and help them come to a resolution. Because the last thing you want is for someone to say they joined your coaching services group, someone stole their ideas and you didn't do anything about it and you let them run amok. So those are some of the common misconceptions that exist. So what should your coaching contract include? Now, in terms of questions, you can always stop me and we can ask questions, or you can ask them at the end. It's up to you. You can just put them in the chat box. So what should your coaching contract include? Before I get into some of the parts they need to consist of, I want to talk about the length of coaching contracts. If there's one thing I've experienced with people when it comes to contracts, is that people get really scared when they start seeing a contract that's like 7 pages long, or anything beyond 2 pages. Everybody gets really, really testy about it. Your contract needs to work for your business. So for example, if you're an online coach, then it needs to have the online requirement. You need to take the online requirements into consideration. And this can include things like the website compliance, so privacy policy, cookie policy, etc., etc. On the other hand, if you're an offline coach, so you only work with people physically one-on-one, you need to address things like liability if there was an accident in your office. So you need to know where your coaching business sits in the industry, and then your contract has to be tailored to that, which is what brings me to the length of the contract. And one of the biggest mistakes that I've seen a lot of people make is they have really short contracts. Many people are afraid of, a 4 to 5 page contract because they think it's too long and it might scare away prospective clients. People will be asking, why do I need to sign so many, why does there need to be so many clauses, etc., etc. However, I always say to people, a short contract is generally vaguely worded and incomplete, in that they will miss out the key sections which might end up working against you. So the way the law works is that sometimes if it's not spelled out in writing, it's harder for you to prove it or to defend it. So it can be easily construed against you. You would think because it's your contract to work for you, but if it's not well worded, it can actually be used against you. So you need to spell out your policies in as much detail and with as much clarity as possible. Another example for you, if you have let's say a 30-day money back guarantee, for example, instead of writing, I offer a 30-day refund, you need, something that's far more clearer and protective. For example, you have 30 days from the date of purchase to request a refund by sending an email to me as this email, at this email address. That's a lot clearer than I can offer you a 30-day refund. No, I'm telling you, you have only 30 days to request a refund, and you have to do it this way, either by an email that I provided, by phone call. You just set out those steps and those rules. That is very, very clear. So if somebody comes after 30 days and said, oh, I want my money back because you have a 30-day back guarantee, did you send me an email? Did you follow the process? No or yes, and then you take it from there. So a coaching contract, the second part, consists of the following parts. The following parts. I didn't put them on the slide because there was a few, but at the end of this, I can always add them into it when I send the slides over to Mary. But some of the parts that it does include is, well, if I'm being honest, I didn't include them because this is my bread and butter. If you need it, call me. So a coaching contract consists of the following parts. You need an introduction. So the introduction establishes the purpose of your contract. It identifies the parties of the contract, which is you and your client. You need your description. What is your program about? What's included? How many hours is it, etc., etc. You need to set out your expectations and your responsibilities. So list all your responsibilities as a coach, what you're going to do for them, everything you're going to do for them and how you're going to do it. And you also need to list the client's responsibilities. What do they need to do back in return in order for them to achieve the goals they have said they wanted to achieve? And also the client's responsibility, because if they don't do what they need to do, you may not be able to do your job, which then just causes a whole load of conflict. Another thing that you need is scheduling and communication. What's your policy on contacting you and rescheduling calls? Is it within 24 hours or 48 hours? Can they call you outside of a certain number of hours, etc.? This is the place where you establish that policy. Investment and payment. What are your program rates? What's the refund policy? Other, payment related issues need to be here as well. Are we talking installment plans? Things like part payment, things like deferred payment. Whichever way your business is set up in terms of payment, you need to have that in there. Another contracting clause that needs to be there is confidentiality. What can they and can they not say outside? It outlines the information that is or isn't confidential and under what circumstances they can say things. Another clause, intellectual property right. You need to establish how your clients can use your content. As a coach, you do end up, providing quite a lot of context. You can give people documents. You can okay, so for example, now Mary is working on Level Up Business Academy. She's going to have a lot of workbooks and content and things on there. There needs to be a confidentiality clause for the client to buy that, because how can they use her content? Some people can download it, copy and paste it, and sell it on or use it to other people. She needs to be wary of that and needs to have that in the clause and the agreement for the people who come onto the academy. These are the rules, and you can and cannot do this. That works with both confidentiality and intellectual property rights. You've also got to have things like personal responsibility, disclaimer. This is where you tell the client what they can expect of your service and what they shouldn't expect. Like I did at the beginning of this presentation, I put a disclaimer. You can expect informational content from me, but don't expect legal advice from me. I'm not your lawyer. We don't have that relationship, so I can't give you actual legal advice tailored to your business that you can then take and run with. So you need to have that. as a coach. One of the examples I like to use for disclaimers for coaches is if you're a coach that boasts that you have 7-figure clients, you have to have a disclaimer that says the results, for example, the results depend on the work that you do. However you want to phrase your disclaimer, it needs to be there, because the last thing I always say you want as a coach is you have a client who is attracted to your coaching services because you do have 7-figure clients, and they come on board, and after 6 months they haven't made 7 figures, after a year they haven't made 7 figures, and they start bad mouthing you, and it becomes a case of, but you know, she says she has 7-figure clients, he says he has 7-figure clients, and I don't have 7 figures. But in the disclaimer, you have said the 7 figures of what you attain depends on the work you put in. So that's there to say, I'm not a magician. It also depends on what you do. You're basically saying that you can't promise specific results effectively, and that your advice isn't, you know, medical or financial or legal, just like how I'm saying for you now. So yeah, you can't provide specific results effectively. And then you have other terms that as a coach you might want to put in there. So these are terms that don't necessarily fit in the ones I've given now. So things like dispute resolution, how they can be terminated. A lot of people don't take into consideration things like governing law and jurisdiction. And all that means is the governing law, since you're based in the UK, is the law of England and Wales. Do not give a contract or sign a contract or anything that says to people the governing law. Well, I can't say do not sign a contract because it depends on the legal advice that you get. But for you, you can't put into your contract that you're giving people that the governing law is Bermuda or Barbados, for example. You're not based there. That's not the law you operate by. So your governing law should always be, in my opinion, the country you're in. And if you're in something like America, it would be the state you're in, because they have different laws for different states. And the jurisdiction is jurisdiction of England and Wales, because if a dispute arises, you want the court that you're going to go to be the one where you are, the one where your law is, you know, where your contract is governed by the law of that land effectively. So how do you use your coaching contract? Now you know how to set up your contract. You have all these clauses in there. Everything has been, you know, read over by a lawyer. It's airtight, it's watertight, it's tight, and you're ready to sign it, and you've signed it. You know, it's a get up. You've got your customers, you've got your clients, you're ready to go. How do you actually use the contract? And it's really easy. When you're working with a client, the first thing they do is pay you, right? So you've spoken, you've agreed that this is what you want them to do, and it's time for them to pay you. Once you've received the payment, you send them a contract for them to sign it, or you can do both at the same time. I know for me, when it comes to my business, I send you everything at the same time. I send you both the invoice and the service agreement. And once they both come back to me, you know, invoice paid, agreement signed, then we can commence with the work. So it's one or two needs to be done in order for you to commence with the service that you're providing. You need to ask them to sign the contract as close as possible to them paying you. And this is because if they don't agree to your terms, you need to refund them. And then you don't want to start the process of refunding. Hence why I say I send mine at the same time. Because usually what they'll do is they'll read the service agreement. If they agree with it, they will sign it, and then they'll pay my invoice. So they all work in tandem with each other. And most of the time, if you've actually had a consultation with this, you know, potential client, they already know how you work. They would already at that point know that they want to work with you, regardless of what is in the contract. So it's less likely that you will get a request for a refund, but just in case, always make sure they sign the agreement at the same time, you know, as paying you, because what you don't want to do is have your first official consult, you know, outside of your free consultation, have your first official meeting or the first official coaching session before they've signed a contract, because then you run a risk of doing it for free, because they'll do it and they'll be like, actually, I don't want to do this anymore. Can I have my money back? And you have nothing to hold them to because you don't have a signed contract back from them. And you don't have a choice but to give the money back. So that's how you need to use the contract. How do you enforce your coaching contract? So you now know how to write it. You now know how to use it. How do you actually enforce it? In most client relationships, both you and the client will walk away happy with your time together. you do hear a lot about the bad, but majority of the time it is genuinely good relationships with clients. So even though you might walk away happy with, I don't know, 99% of your client, there might be the 1% that you're unhappy with. So you need to actually learn and know when and how to enforce your contract. Be comfortable with holding your boundaries. I always tell people this. A lot of people find it once, they're being challenged by clients, they get really shaky, like, oh, I don't want trouble. I don't want them to give me a bad review. I don't want them to give me a bad name. So let me just let it go. No, you have a contract with them. So be comfortable with enforcing that contract. So when should you enforce it and how? So you have a right to enforce your contract anytime. And I mean, anytime a client oversteps a boundary and a client that doesn't hold up their end of the bargain. In other words, and what we say in the legal world is when a client violates a term of the agreement. So all those clauses that you've learned to write, if a client was to violate them, for example, let's say the confidentiality clause, they went and they broke that clause, you have every right to terminate the contract. You have every right to enforce it and say, this is the consequence. Well, this was the consequence you agreed to if you were to break one of these terms. So time to pay up. This is what we're now doing. So, and it can take many forms. It can be something as easy as calling the client and discussing the situation, or sending them an email, all the way through to bringing an actual lawsuit and going to court. This is very expensive. So this is something you have to think about in terms of what is actually at stake. So the best option is to send your initial correspondence by email rather than a phone call, because then you have a thread of everything. I'm an advocate of, even if I were to be on the phone with you and we agreed something, please send me that in an email, or I follow up with an email. Because what then happens is one of you would have to dispute what's in the email. So if I have a conversation with someone and I send them an email, say following our telephone conversation, if the content is wrong or they don't agree with it, most people will email back and say, oh no, this was it, or it was this. So always have, the initial correspondence by email, and that way you have proof, that you've reached out to the client in writing to try and solve the situation. There's proof of the date on the email as well. So when it comes to the enforcement process, there's a step-by-step process, and I have 3, which is just breaking down some of the things I've just said. Step 1, you try to enforce the contract amicably. You send a few emails and try to get the client on the phone, try to resolve this like normal, level-headed human beings. Step 2, if that doesn't work, you get a lawyer involved and you write a cease and desist letter, basically saying, look, I'm A, B, and C, this is what you have violated, cease and desist, stop doing this, or whatever it is whatever action it is you need them to take, that will be in your cease and desist letter. And step 3 is the biggest step, and that's to enforce a conflict resolution clause. So either court or mediation or arbitration. Now, when it comes to the conflict resolution clause, this is something you already would have had in your contract. So there are lots of people who put in their contract saying, if something were to happen and a dispute were to arise, we would go through mediation or we will go through arbitration, because these are cheaper options to going to court. So what happens is the third step is whatever your contract has stated would happen if a conflict were to arise. This is a whole process, and it comes with a lot of costs. So you should always, only sue on a very small number of cases, and it's always if needs be. If you can settle outside of doing mediation or arbitration or anything like that, always do that option first. Never just go straight to, I want to sue them, I want to take them to court. So those are the 3 steps. There are other legal considerations as well when it comes to contracts, and 3 of them that I feel like are also important as well. And other ways you need to comply with the law, and some of the questions I usually get have to do around the 3 things on the screen now, which is like, do you need insurance? So a contract is actually the first step before you get insurance. That's what I would recommend, and that's because a contract sets out the boundaries for your business. So the next step after a contract is to get insurance. In most cases, you're not required to get insurance, But in some industries, for example, if you are a health related industry, you may be obliged to get insurance. So my advice in terms of insurance would be know what is required in your industry and then take it from there. The second one is surrounding things like GDPR, email marketing, affiliate marketing, spamming people's emails. There are actually laws against you doing that. So all this actually comes down to treating your community members with respect. If you treat them with respect, if you respect them, you're not going to spam their emails. There's a difference between your email marketing and then just bombarding them with emails as well. So you need to have a clear sign on your email opt-in form. For example, like a pop-up that might come up on your website that says people are going to be added to your email list. So they need to know that. A lot of people as well have like a double email opt-in button, which is once they've signed up, even though they've clicked it, when they get into their email, there's another confirmation they have to tick just to say they are signing up for your email. And I always recommend don't send newsletters to people who haven't signed up for your email newsletters. Just because you have the email address doesn't mean you have the right to send them an email, because they could have actually opted out of it. So that might actually just come down to the CRM system you use. Maybe that would help separate it, but that's the general rule and the general way to respect people, in that regard. And finally, it's about international clients and legal considerations. Again, it goes back to what I've said before. You want to make sure that your governing law in your contract states that it's the law which will govern your one-on-one relationship in the country you're in. So if you have international coaching clients, I will still always recommend that your governing law is that of your country. It's up to the client to decide if they still want to work with you, but always protect yourself first. And if you want to reach out to me, this is where you can find me. I feel like I have spoken a lot and I have rushed it. I really hope I haven't rushed it.
Amazing. No, you didn't rush it.
Okay.
And I don't know, before I have a question, and it's something I saw on Facebook yesterday. But before I ask my question, I just want to ask Maggie or Shani if you guys have any questions regarding contract. Do you guys have contract in place?
Mm-hmm. Yep.
Mm-hmm. Yeah, I love it. And then based on
That's
what
good.
Ayo just mentioned, is it in compliance with what Ayo mentioned? Like the set of things you include in your contract, does it have it?
Yep.
Oh, I love this. Okay, I love it. What about obviously, because everybody has website now, for example. So the website, or I think I mentioned things like you should have on your website, the privacy stuff, affiliate marketing and things like that. Because for me, for example, and I'm glad I mentioned that. So I'm building an academy, and I just finished doing, I've done my slides, I've done my workbooks, and then she just mentioned about intellectual property. Like, oh my goodness, I need to, put that clause on the side, like, you cannot share this, you cannot resell this, all this kind of stuff, right? So I'm like, oh goodness me, I have to think about that, right? So all this, even my website, I feel like is not really compliant, to be fair, if you would really, really want to look at it. So I love that you mentioned this, like all of us just think of contract and that's it. But there are other areas that we should also kind of pay attention to that we normally wouldn't, And so I just want to ask, obviously, Shani or Maggie, what your thoughts are, like when it comes to website, intellectual property, do you guys have some things in place, or even insurance for your business, for example? Do you guys have those things in place?
Oh, that's interesting. For me, I have insurance for myself as opposed to, the indemnity insurance type of thing.
Uh-huh.
That's what I have, because the type of clients I work with would be those type of clients who would most likely not actually understand, because I do a lot of mental health type of coaching.
Okay. Yeah.
So it's that whole thing about actually being very, because you're dealing with sensitive issues and sometimes emotive issues, and somebody might not have capacity to actually understand what you're doing. So it's just being very careful in terms of insurance to cover yourself if they come back and say, no, I don't agree with this and things like that. Yep.
Yeah,
That's
I
it.
like that. Yeah, I
Yeah.
love that. I have an insurance myself as well. And I think all coaches should have insurance because you don't want someone to come in for you. Like, well,
Mm.
you said that. And then like based on what you said, just made them do certain things and then it's cost them God knows what. And then they're
Yeah.
coming for you. It's like,
Yeah.
okay. So it's
Especially
really
if you're
good
a
that
coach
you have
that's
that.
licensed, that could
Ye-
cause you big problems.
Yeah.
Yeah.
So I have a quick question. So I saw online one of these Black business groups, and a lady has come to rant really and to ask for legal advice. So she has two clients. She's based in the UK, but she has two clients based in America. I think Florida, Miami, one thing I can't remember, but America though, and they've not paid her. And she's done all she could, but they don't want to pay and things like that. So, because you mentioned that, so some of the feedback or the responses that people are saying, to be fair, is that that the lady saying there's a few thousand that they owe her, but if she wants to really drag it, she might spend more than what they owe her. That it might just be a learning experience for her to take and learn from it and just let it go. And that the for other thing they said was which country's law would then obviously take precedence over this case, for example, right? And if they're based all the way in Miami and you're all the way here. So when you said that thing about international clients, that of course, that when you do your contract, the jurisdiction should be your country where you, the coach, is resided. So now you have things like that where the client is in Miami or Barbados and they don't want to pay or they're acting up. So how do you then deal with that?
So, like I said, I always recommend that your governing law and jurisdiction be the country you're in, because if it ever goes to court or anything happens, you want it where you are, where the law is. I don't want to say favorable to you, but you can hire your own lawyers here who know the system and know the law. You want that. But in terms of international clients, to do anything further when it comes to things like this, you're going to need to hire a lawyer anyway. So the best thing to do in her circumstances, if she had the money and the funds to do it, is to hire a lawyer in the state that those people are in. Again, I say state because in America, every state has their own their own laws. Yeah. So if they're not in the same state, that's again going to cost her a bit more money because she's looking for somebody that's experienced. And in America, they're mad. Just because you can practice in one state doesn't mean you can practice in the other state. To me, is mind-boggling. So so if they're in two different states, she'll need to get someone in each state. But that would be my way, to go about it. Get a lawyer who's based out there who can easily reach those people and send her cease and desist letter, because obviously they're thinking she's in the UK, there's nothing she can do to me.
Right.
So if she really wanted to drag it, it's about getting a lawyer in those states and saying, look, this is the address, I want you to send a cease and desist letter.
Yeah.
And then they can better also advise her what the repercussions can be in their state, what she can file in that state, etc., etc.
Okay. Oh, okay. So even though it's not in a contract that the jurisdiction country is the state, she can still hire lawyer.
Yeah, no, the jurisdiction and the jurisdiction of the governing thing is to do with if it was to go to court, this is where it's going to be heard. But nothing in that stops her from going to a lawyer and in that state and saying, I want to hire you to write a cease and desist letter for me in your state. Because I'm just paying for their services. It has nothing to do with, it's not in my contract. I'm just paying a lawyer in America or in whichever state to do a service for me.
Okay. So if it then does go to court, so England, for example, I'm in
this
England.
Country.
So then would there be a letter sent to them to bring them to England? Or what would happen?
I don't think so. The thing is, I don't want to say they have to appear. I don't believe they would have to appear in court, but it's heard in this court. But the truth of the matter is, with things like this, I don't see, unless it's like millions being owed.
Yeah.
Most people will stop when they feel that, when they see that they're spending more than they're actually owed. It does not make sense if you owe me £1,000, but I'm going to end up spending £10,000.
Yeah, of course. But it's very, very unfair then, in the sense that...
It is unfair, but I would always recommend, if she can find a lawyer who can do it reasonably priced, send them a cease and desist letter. Those things are just to shock people and to scare people. So it's for them to know that actually I might be in America, but she can still get to me.
To get to me, yeah. Okay, that makes sense. Because some of us, I'm sure we are international coaches. We coach people out of the country, so you have to be careful. Because I've had situations where clients, even though it states in the contract, even we've both agreed what your payment plan is, and then you get clients coming to you now dictating, oh, because I don't have a job now, so this is what I'm gonna pay. So what now?
No. And another
no.
thing you can do if you wanted to is
Yeah.
register your company
Mhm.
in the country where you. So let's say I'm going to use Canada because America
Okay.
is just too many
Crazy.
states. You have to register too many places.
Yeah.
Let's say Canada, for example, you can actually register your business in Canada, have an online office in Canada or something like that, have a jurisdiction in Canada, like let the jurisdiction be Canada. So when a client in Canada wants to sign up with you, they're signing up with you, but under the Canadian company as opposed to the UK company.
Right.
So it's still in their jurisdiction.
But then you'll be subject to double tax. Well, not double, but Canadian tax and the UK tax.
Yeah, I don't know what the law is, but it's just another option of what you can do to be in that jurisdiction. You would have to. It's all about doing the research to find out.
Yeah.
To find out what the taxation rules will be, or if it could be, or if you have a sister company there, but then it's not domiciled there.
Yeah.
So many different rules, but it's just another option for coaches who want to do international coaching.
Yeah. Okay.
Because if you look at these
sense.
big people, a lot of them have their companies registered in key countries.
Yeah. Okay, that makes sense. Thank you so much, Ayo. Shoni has said she doesn't have any question, and I think because she's still in the education mode, learning from experts in the areas that she wants to coach in, which is fantastic. And I think this class tonight or this webinar tonight is also a great one, education mode as well, because now when I'm ready to coach my clients, I need to put this contact in place and have this in place.
Yes.
Exactly, which is really, really cool. We are going to send out the slide, and we're also going to send out or upload them on our resource hub on our website, so you can still have access to it and replay. So everything that I have mentioned, even if you're not jotting it down, you can have access to it over and over. So, but yeah, honestly, thank you so much, Ayo, again for your time tonight, for spending your beautiful Thursday night.
Thank you for having me. So I'm just making notes to send you the slides.
No problem. I'll come and hand you. But thank you. Really, really appreciate your time as usual. But yeah, if there's anything from the group, any question from the group, we'll let you come to you and let you know. But if there are no more questions, we're gonna have to end it there. Thanks, Maggie. Thanks, Shoni. Thanks, Shirin, for joining, guys.
Have a
we'll
good
catch
evening,
up soon,
everyone.
ladies. Take care.
Bye.
Bye.
Thank you. Bye.
Um,